Hello, I'm Michigan Attorney General Dana Nessel. Today I'm announcing the results of two important criminal investigations handled by my department's Public Integrity Unit. In each case, our own investigators and assistant attorneys general conducted dozens of interviews and reviewed hours of video recordings, documents, and reports to arrive at their conclusions. As with all our public integrity cases, our investigations are conducted impartially by a team of career prosecutors and agents, and with the knowledge that public officials hold a special position of trust with the public, and thus the public has a keen interest in knowing how and why decisions are made when allegations of wrongdoing arise. For that reason, I'm here to publicly report our findings in two cases arising from officer-involved shootings, one by an officer in Macomb County's Shelby Township and the other by a Lowell police officer. I'd like to first remind everyone that a criminal charge is merely an allegation, and defendants are presumed innocent unless and until proven guilty in a court of law. First up this morning in 64A District Court in Ionia County, we charged Lowell police officer Jason Diaz with one count of assault with intent to do great bodily harm less than murder, a 10-year felony, one count of misconduct in office by a public official, a 5-year felony, one count of weapons, careless discharge causing injury, a 2-year high court misdemeanor. These charges stem from allegations that while on duty, August 29, 2020, and after a high-speed chase through both Kent and Ionia counties, Officer Diaz fired his weapon 8 times at a fleeing vehicle in violation of both the law and Lowell Police Department's use of force policy. It also alleged that one of these shots struck a passenger of the car in the head, causing an injury. Officer Diaz was arraigned this morning. The next case involves a Macomb County Shelby Township police officer, Jason Zook, and whether or not he legally used deadly force by discharging his firearm in an interaction with Conwember Malai, who died from a single gunshot wound at the scene. Shelby Township police were initially sent to Mr. Malai's home on November 1st, 2018 for a mental health call. Malai was 25 years old and suffered from mental illness. His mother had called police out of concern that her son was suicidal. Mr. Malai was uncooperative and refused to be taken to the hospital. He then took his mother's car without permission, and she reported it stolen the next day. Late that night, a Shelby Township police officer saw the stolen car through an apartment parking lot and pulled into a parking space. For 8 minutes, the officer first asked and then demanded that the driver, who was Mr. Malai, show his hands and hold his hands out the window. Mr. Malai refused to comply with the orders. He said he had a gun when he was asked about having weapons. 2 other officers arrived as backup, including Officer Zook. Given Mr. Malai's threat, both officers drew their weapons. Our investigation showed that Mr. Malai refused to comply with more than 70 loud verbal commands from the officers to show his hands. He also turned toward the back seat, leading officers to believe he was retrieving something, then appeared to search in the console. The evidence showed that Mr. Malai finally opened his door of his car and left the vehicle. He made a sudden movement toward the front area of his body, which led officers to believe he was reaching for a weapon. Officer Zook discharged 1 round into Mr. Malai. Law enforcement officers have the same privilege of self-defense as anyone else. Shooting a gun in self-defense requires an honest and reasonable belief that a person is in danger of being killed or seriously injured. And if that person's belief is honest and reasonable, he can act immediately to defend himself, even if it turns out later that he's wrong about the level of that danger. Based on a review of the facts and the law, Officer Zook's perception that Mr. Malai presented an immediate danger of great bodily harm or even death to the officers surrounding the vehicle was a reasonable one. Mr. Malai's continued and prolonged refusal to comply with police commands, coupled with his statement to officers indicating he had a weapon, formed a reasonable basis for Officer Zook to believe Mr. Malai posed a threat of serious bodily harm or death to himself and other officers on the scene when he reached for his waist. Now, after a review of video recordings, interviews, police reports, and medical examiner's reports collected as part of the investigation conducted by the Macomb County Sheriff's Department, we have determined that there is insufficient evidence to charge Officer Zook with a crime. He acted with an honest and reasonable belief that he and other officers were in danger of death or great bodily harm at the time he fired the one shot. A memo outlining the facts of this case will be posted on our website today. So in closing, let me say this. Last year, I announced that my office would focus special attention on officer-involved shootings and in-custody deaths. These are challenging cases that require a careful and thoughtful review to ensure the trust of the parties involved and the confidence of the larger public in the process that we use. To meet that challenge, we are committed to conducting each review without preconceived notions or predetermined outcomes. Instead, we will reach our conclusions by following the evidence wherever it takes us. Thank you.